Welcome back to Good Law, Bad Law. Our guest today, Professor Kellen Funk from Columbia Law School. Professor Funk also with a PhD in history and a specialist in American legal history. This is part two of our series on bail reform. And as you'll hear, really, you can't talk about bail reform without getting into the much more sprawling and but especially important issue of criminal justice reform and prison reform. I was staggered to learn, as Professor Funk explained, that there are on any given day in this country 500,000 people in pretrial detention, people who've been accused of a crime but haven't yet been able to be tried on that crime, and are in detention, are basically serving in jail or prison because they can't afford to make bail. The tremendous disproportionate impact on communities of color, on lower income, lower wealth populations in our country, clearly evident in the issue of bail and the problems that we have trying to figure out a way to address these systemic problems with our bail system. I think in 50 minutes, Professor Funk has really treated us to a seminar on this topic. And I know I learned a lot. I know you will learn a lot. Probably the biggest takeaway is just that we need to understand this issue and the issue of criminal justice reform. We need to be aware, we need to be educated so that we can participate in the debate over how to address these problems. And so I'm really proud that we're doing a small part to accomplish that. So stay tuned for this episode of the podcast with Professor Kellen Funk from Columbia Law School. Stay tuned and enjoy this episode. I want to welcome my guest today, Professor Kellen Funk from Columbia Law School. He's a professor there, also has a PhD in history from Princeton, and concentrates in American legal history, including the subject that we're going to be talking about today in part two of our series on bail reform. And Professor Funk has written about this issue, which has long been a part of our criminal justice system in the United States. So first of all, thank you and welcome, Professor Funk. Thanks so much for being on Good Law, Bad Law.
My pleasure. Thanks so much for the invitation.
So as I was explaining before we got started this morning, and forgive me for being in tennis clothes this morning too, some things can't be helped. We had a guest on last week talking about this issue from the standpoint of the insurance industry. And I felt that there were a lot of parts to the story and a lot of facts about the impact of bail in our criminal justice system, particularly on people of color and people of lower socioeconomic backgrounds, that he was not really as sensitive to, I think, as people should appreciate the need for being sensitive to. So I was grateful that you agreed to be on and can give us some different perspectives on this issue. Give us, if you would, give us some background on yourself and the work that you've done in looking at the history of law in this country. I know you have a book that's, I believe, recently come out on that topic. And in particular, your interest in this issue in bail reform as it fits into the broader subject of our legal history and where we are today.
Sure. So I should say at the outset, I haven't had a chance to listen to last week's episode, but I'll be very interested in returning to that. And there may be some surprising confluences. There's a way in which bail reform can make some surprising bedfellows, as it were. A lot of times lawyers for the surety companies, the insurance industry, and the American Bail Coalition are often in favor of some of the especially procedural reforms that bail reform advocates press for, but maybe not necessarily the substantive reforms that we'll talk about. So my background, as Aaron said, I am trained as a legal historian with a PhD in history. My legal history work from my dissertation days was really focused on the history of civil procedure in the United States, the development of the legal profession, and really our commercial practices, our commercial debt practices, and how our system evolved from the old sort of common law writ style of pleading to the modern system we all learn in law school under the federal rules of civil procedure. So believe it or not, no one's ever invited me on a podcast to talk about the deep history of civil procedure, but I've found a lot more requests coming in once I've turned my attention to this related but kind of very different field of bail. So it's kind of a natural topic for a legal historian to take on. Bail is one of the oldest English legal institutions we still have in operation today. It's older even than, you know, the 12-member jury that we use in civil and criminal procedure. But it's one of those topics that has kind of evaded the notice of the Academy for some time. It sort of falls in between the gaps of our academic silos. Bail, pretrial detention is very much a part of criminal procedure, but so many of the processes and the mechanisms that make it work are really, you know, they're commercial debt practices. They're what you were talking about last week. They're insurance and surety agreements and contracts. So it's almost too much of the world of civil and commercial practice to have been of intense importance to criminologists. But it's very much too much of the world of crime to have been of much interest to proceduralists and those who work on private and commercial law. And I think that's been really changing in the last few years as people have seen just how fundamental bail and pretrial detention is to our system of justice, how much it gets caught up in the politics of protest and reform movements, that there's an increasing amount of attention being paid to it. But it's one of those fields that is really resistant to deep study because it has so many, you know, archaic and obsolete, seemingly obsolete, but still very much alive, you know, historical procedures in place. You almost need to have spent 10 years studying the writ system to even get a grapple on some of, especially the deeper history of the bail system and how it worked. And so my attention was turned to this in part through a clerkship when I was working on a case related to a constitutional challenge to money bail, and then as a legal historian asking questions of where did this system come from? How do we have all of these pathologies that we do in this system? And then, you know, kind of finding to my amazement that even though it's sort of right next door to the thing I've spent my career studying, there's been just very little academic attention paid to this. And so I'm trying to pitch in where I can and excavate especially some of the history of this system.
Well, and like so many issues today in our politics, including issues that involve questions of reform of the law in one way or another, bail, it seems, is very easily susceptible to politicization. You know, you can go from a position on bail very, very smoothly and very quickly to, we're going to have more crime, or this is, you know, this is a relic of structural race. You know,
Right.
it just fits so quickly and easily into, you know, politicized and very polarized camps. And that's why I think it's so helpful to be able to look back at some of the history and then relate it to where we are 230 or 40 years into our history. So
yeah, I teach a seminar on the bail system at Columbia, and you know, I think at first some students think that's a pretty super narrow topic to spend a whole seminar on, but then you quickly realize that bail is caught up in, you know, such a larger web of criminal justice, civil justice, professional reform that it really becomes a class on law reform in general, and what kind of stances and horizons are open at these various dimensions on law reform.
Well, that's a great jumping off point. So maybe you could say a little bit more about that if you were talking to a prospective student on why they should take that seminar. That probably is a good intro for our listeners too, and why they should understand bail for itself, and then how it fits into the broader questions we're looking at.
Sure. So I begin my class with a vocabulary lesson, which may be the place to also begin here, because we mean so many different things by the use of this word bail. So what we often mean just in casual conversation is release from pretrial detention, or the collateral, the security interest that secures that release. So we often think about bailing someone out, or whether someone is able to make bail, and we mean, are they able to pay the money amount that is required either by the court or by a commercial bondsman, which we'll probably talk about those mechanisms in some detail as we go along. Is the person able to pay that amount to get out of detention pre-trial? So bail belongs to the world of after someone has been arrested or charged with a crime, pending trial, which depending on the jurisdiction in the United States, trial can take anywhere from several weeks to several years. And so whether someone is detained during that period or at liberty is just a hugely impactful decision on the lives of defendants, on the lives of communities, on the court and its processes. Historically, the technical legal definition of bail is custody. So looking back at my materials from the early 19th century, bail is always a word that refers to a person, not release, not money, but the person who is standing as surety for the defendant, who is assuring that the defendant will return to court. And bail is understood universally as a transfer of custody. So it's not that the state ever really relaxes its grip on you. It's just that you are transferred from some kind of public incarceration, publicly maintained jail, to a more kind of private custody of your surety. At least that's the way the system is understood in the 19th century. So as we're talking about bail, we're really talking about this whole system of pretrial custody, whether the person is in the hands of the county jail, the warden, the sheriffs of a municipality, or out at liberty, but subject to monitoring conditions by a commercial bondsman, the people who run the shops with the neon signs down by the courthouses, or even are out on what's known as your own recognizance release. That is, you are your own custodian, but still that concept of custody is there. You are sort of always under the custody of someone, even if that someone is going to be yourself in certain instances. So if I were advertising the class and the importance of the subject, I would say, first of all, as I think I've already indicated, just that binary decision over whether someone is going to spend their pretrial custody in a county jail or at liberty in some meaningful sense, whether they're going to be able to return to their families, to their jobs, be able to sort of maintain housing arrangements and child custody and all of that, is a hugely monumental decision in the lives of people individually, but also has just huge systemic effects across communities. And that would be the sort of second important point. Is that on any given day there are half a million people in pre-trial detention across the United States. So they're not tried, they're not convicted, but they are being detained usually in the exact same conditions and with the exact same population as convicted criminal defendants. And despite much of the United States rhetoric about presumption of innocence, the importance of having a lawyer and the ability to mount a defense, the idea that what makes us distinct from totalitarian systems is the government cannot jail you on a mere accusation. You know, the lived reality across much of our system and in many of our counties and municipalities is that the government can, in fact, detain people indefinitely on a mere accusation. And it's just an almost fictional money amount that accomplishes that detention.
What do you mean by that, a fictional money amount?
So across most states, going back to the time of William Penn, who was the author of this particular provision, most state constitutions from the colonial era to today, there have been some amendments, but really across the board, most states forbid judges to order detention outright, except in capital cases. So for many states, and again, there have been some reforms to this system since the 1980s, but even there, the eligibility nets for detention remain pretty strict. So in most states, in most counties, a judge cannot write an order that says, you know, for whatever reason, I think you're a risk of flight, or I think you're a danger to a community, therefore you will stay in jail until your criminal proceedings are concluded and a verdict is reached in your case. That order is illegal under state law. But what is not illegal is for a judge to, you know, to have a case that is transparently, you know, a crime of poverty, something like sleeping at a bus stop, you know, a trespass charge, and to set some astronomically high bail amount to secure the release of that defendant pending trial. So you know, it's very common to see these cases of the charge is trespass for sleeping at a bus stop, using a restroom at a hospital or something, and the bail amount set is $5,000, which the defendant obviously cannot pay, you know, just off the face of the record. The defendant obviously would not be able to pay that. And so the effect is the same. The defendant is detained pre-trial. Now, if the judge had written, you shall be detained pre-trial, that would be illegal. But if the judge writes, you shall be released upon payment of $5,000, the detention that is accomplished there is perfectly legal under state law. The ongoing debate is whether that's allowable under the federal constitution, which is where there's a lot of litigation action today. And so the reason I say almost fictitious is that it's sort of manifestly evident that many of these defendants cannot pay the amounts that are being set. So it's quite clear that the money amount is being used to accomplish detention. It's a really perverse irony of the bail system. The whole point of bail was to accomplish release, and yet the money amounts are being used to accomplish the very opposite. And the other thing that really makes this a kind of almost fictional system is that money amount is really just drawn out of thin air. Why $5,000 for this particular defendant? Many counties use bail schedules. That is, it's the judges all have a chart that say, you know, if the charge is this, if the criminal history is, you know, there's this many prior arrests or prior failures to appear, then the bail amount shall be this, and kind of a graduated schedule. As the charge gets more serious, as the criminal history gets more lengthy, the money amounts go up. But the thing about those money amounts in every single jurisdiction is they are just picked out of the air. There has never been sort of an actuarial attempt to predict what the risks are for particular defendants and what the costs to the criminal justice system or the public or whatever would be that would justify this particular amount. It's more or less a council of judges or legislators sitting around at one point or another and decided that, you know, low-level misdemeanors will be 500 and high-level will be 5,000 and felonies will be 25,000. And those numbers are not related to anything at all, except, you know, what struck the intuitions of some legislators at one point as a serious enough bail to release someone on a serious charge.
Right, and I was thinking about that as you were giving the example of the homeless person in a bus station, and obviously they don't have enough money to pay $5,000 bail. Other parts of our system where there is at least some attempt at rational distinctions, say in sentencing, maybe overly rational according to the critics of the federal sentencing guidelines, not leaving enough discretion in the hand of judges to depart from those guidelines.
Don't mishear me as recommending we should bring the actuaries into the bail system necessarily. There is a way you can sort of over objectify this and try to scientize it and lead to all kinds of perverse results.
Right.
But it certainly is true that the system is just very arbitrary as currently constructed. Yeah.
And if you're going to have judges have more discretion, let's say this county or the state guideline, if you will, is X dollars, you'd like to think that a judge could apply particular facts of the particular accused person in front of that judge to depart from those guidelines to try to achieve the goal of bail.
Yeah.
Now the person we had on last week, was really arguing. He was arguing on behalf of the insurance companies that write policies for bail bonds, and wasn't really that sensitive to the issue either of overcrowding of prisons. I mean, I think most people know by now that we are we have the most incarcerated population, I think, in the world, in this country, and 500,000 people, as you've told us, in pretrial detention is a pretty staggering figure in itself. Was not really very sensitive to that issue or to issues of inequality in the way bail disadvantages people, particularly people who can't afford to make their portion of bail. But on the other hand, if you're going to give discretion to judges to depart from guidelines, you'd really want their consciousness raised about this entire issue so that they're sensitive to the problems of setting bail at such high levels, or the disproportionate impact that high bail levels have on relatively disadvantaged communities. So how do you do that if you're not going to bring in the actuarial folk, and you don't like the idea of rigid algorithms that don't cure these structural problems that bail creates? What is the answer to that?
Yeah, that's the really difficult question. I mean, so we're in an era of bail reform right now, although, one could have said that at basically any time in United States history. The bail system is just one of these systems that is always being reformed and somehow never getting reformed, it seems. And there's a way in which, the reform of each generation becomes like the malady of the next generation. So bail schedules are kind of our present malady, where they're sort of not related to anything real about the risk of this particular defendant in this particular case. What we find is that bail schedules are being really inflexibly applied, and judges are not using their discretion, especially not to depart downward from the schedules in a way that would actually release defendants. But judicial discretion can have its own vices and traps, and really where we got bail schedules from was to respond to the problem of judicial discretion, because in the 1920s, before we had bail schedules, judges did set bail according to their discretion. And what reformers in that era found was that, on the same charge, in the same circumstances, maybe even when defendants were accomplices of each other to the same crime, white defendants would be given affordable bails and release. Black defendants or other defendants of color would be given would have unaffordable bail set or additional conditions set on them that were not set on other defendants. And so bail schedules at the time were like the leading edge of progressive reform. This was going to be the way to equalize and bring equity to the bail system. And now in our generation, we look at bail schedules and say, how do we find a way to equalize and bring equity to our system that is so dominated by these things? Yeah, the reason this is such a difficult question to answer is it's a question that just, it may not have a handy legal answer. I mean, there are definitely things you can do legally. You could take the bail schedules and you could lower them across the board, or you could tie the schedules to non-financial conditions, right? So if the charge is drunk driving, there has to be some kind of cooling, sobering up incapacitation period, but it's not related to whether the defendant can pay something or not. And after that sobering up period is ended, the person is released. That could be your bail schedule. Or if you do have financial amounts on the schedule, those could be treated as, a maximum ceiling instead of as they are currently treated as a floor for defendants. You could multiply the procedures that judges have to go through, and here again, this is a reform that bail bondsmen themselves can really be in favor of, because I mean the commercial bail industry isn't pleased with the fact, right, that 500,000 people remain detained pending trial. They would like more people to have access to their services, and to the extent that money bail is actually releasing people, it's performing some good, some relative good, and at least performing its historical function. So you could layer on a bunch of procedures that judges have to go through currently. And you can find many of these videos on YouTube now. Bail hearings for defendants in many counties, they last literally a few seconds. The person is told not to speak. They're often uncounseled. They appear before the court, often by video link. Before the Zoom era, the bail hearings were the ones really pioneering video link conferencing. So the person hasn't even really left the jail. They walk up to a monitor, they're shown a judge, the judge reads off the bail amount, there's no discussion, and the person is sort of returned to their cell until they come up with the money to pay the bail amount. So you could layer on a whole bunch of new procedures, make those hearings counseled. There are constitutional arguments that maybe those hearings must be counseled under Gideon. Supreme Court hasn't spoken to that precise question yet. You could have written opinions. You could sort of put the process burden on the judge to justify the bail amount and the detention. And once you start piling work on judges, that if they find that the easiest way to get around the work is to release defendants, maybe they'll start doing the easier thing and releasing defendants. But the really deeper problem, as I think that your question indicates, Aaron, is really kind of a cultural problem, that just the judges come in with this situation sense that detention pending trial is kind of normal. It may actually be the result to be achieved. And this sense has a whole lot of inputs to it. So there's just no one part of the system to reform. I mean, in many counties, especially true of New York City, the bail docket is kind of the first posting of a judge once they are elected to the bench. So it's people without any experience at all being judges, and they come in on day one, and so they're necessarily looking to the people who have been there to tell them how the system works, how should things be done. So there's just that kind of natural mechanism for perpetuating the older practices. It's partly a problem of the local press. Anyone who's out on bail who does something heinous, whether they were released without a financial payment, whether they paid bail, and they were under the supervision of a bondsman, anyone who is out pre-trial and does something heinous, the judge knows their name is going to appear in the paper and they're going to be blamed for that one thing that happened, no matter how anecdotal it is. Whereas, 10,000 people remain detained pending trial, and they shouldn't have been, the judge will never have to take flack for that. That will never come up when they stand for election again. And so, how do you change that? You got to talk to the New York Post and everyone else.
I was just going to say, in states where judges are elected, which is many states, Pennsylvania, New York, judges, you wouldn't think judges would be or should be sensitive to when their name gets in a newspaper, but the reality is they are. So that is a big issue. And then the broader issue of how do you think about reform? It sounds like you can't really separate this issue of bail reform from the broader issue of prison reform. And we still don't have a good answer other than incarceration, as an answer to crime. We don't have an answer to policing. We don't have an answer to over-prosecution. We don't have an answer to over-incarceration in this country.
Yeah.
And
so there's kind of a dark side and a bright side to that. I mean, the dark side is, in the moment you start to touch on bail reform at all, it's very easy to get overwhelmed and think there's nothing that can be done because, all of our problems with bail are really symptoms of much deeper problems of over-criminalization, criminalization of poverty, incarceration as our sole response to mental health and social problems. It's also, even if we did decide that bail hearings needed to be lawyered, like where are those lawyers going to come from? We certainly don't train our elite students to be doing these things that are going into corporate law firms. We don't make legal education affordable enough for there to be lawyers to fill that demand. So you start pressing on these things and you end up what feels like 1,000 miles away from bail and saying we got to fix that first before we can even kind of talk about bail. The bright side of that, though, is that it turns out kind of any justice reform ends up being a bail reform in the end. And so, there are bright spots on the horizon. I think I just saw yesterday, maybe, or the day before, Nevada. So I think the governor's signature is still pending, but Nevada the legislature has just moved to make all traffic offenses non-arrest. So, bail, as far as I know, does not appear on the face of that bill, but that's a major bail reform in that it just takes a whole population out of the arrest and pretrial detention system. And will now start create easing conditions across the rest of the system in Nevada. So that's a tremendous reform for bail.
So, okay. So again, this figure of 500,000 people in this country on any given day in pretrial detention, I find that really a staggering statistic. You mentioned some of the ways in which bail could be used, frankly, as part of Jim Crow, is in very openly, racially, in very racist ways, let's say. Back in the 1920s was the example you gave. What do we know about this 500,000 people on any given day in pretrial detention in 2021? Can you give us any sense of the impact of what we've been talking about regarding bail as seen in the makeup of that population?
So I'll start by saying it's actually hard to be precise about figures across the bail system. This is another kind of day one lesson of my bail seminars. Especially we talk about the American bail system. Bail is an intensely local creature. And so the exact array of bail mechanisms and who has authority over the system, many people are surprised that places like Houston, third largest jail in the country, actually prosecutors don't have much input on bail in Houston. So it's not really a prosecutorial reform that's needed there, although I mean their prosecutorial reform is always needed, but it's not that there's a direct link between what the prosecutor asks for and what is going on in the bail system. Contrast that with like New York, San Francisco, where prosecutors are basically the ones driving the bail that is requested and eventually set. So all to say, we don't have an American bail system. We have, conservatively 5,000 American bail systems, and some of them keep better data than others. So we don't necessarily have like the precise breakdown across that 500,000 on any given day in pretrial detention. But to the extent we have precise numbers in certain local systems that keep track of these things, the numbers are sort of exactly what you would expect. Hugely disproportionate rates of detention on defendants of color, way out of proportion to the population of the local community in that area. All sorts of ways in which these disparities get ingrained into the bail system. This is partly continuing our discussion that we were just having, that bail is a symptom of so many other pathologies in the criminal justice system. And this is where critics of algorithmic risk assessments get a lot of traction on their arguments. So there are moves in some jurisdictions to move away from both bail schedules and from judicial discretion and say, we're just going to run the numbers and come up with a risk score that is, not taking into account the defendant's poverty or something, but just their past performance history with trial dates and things like that. I mean, the problem with these risk assessments, there's a great article by Sandy Mason called Bias In, Bias Out. To the extent they are drawing on historic criminal data in a jurisdiction, they are drawing on systemically biased data in a jurisdiction. So a community that is over policed is going to have more arrest records, so that when you plug that into the algorithm, they are going to appear at higher risk. And the intuitive interpretation is they're at higher risk of endangering the public, when really all the score is telling you is that this is a defendant who is at higher risk of coming in contact with the police again. Right. Which is a very different thing from endangering the public in certain communities, right? And so that's really the way, both bail schedules on their face discriminate against the poor to the extent that poverty is more highly correlated with race in any given community, which is basically every given community in America. So bail schedules are going to work not just a class inequality, but a racial inequality. And even our presently proposed solution to bail schedules, algorithmic risk assessments that try to de-bias the schedules, to the extent they still rely on historical criminal data, they're going to keep perpetuating, historic criminal biases.
So, excuse me. So given all the challenges that you've identified to trying to think about bail reform that could actually produce positive change, and I assume that has to include less of an adverse impact on communities of color, less adverse impact and less disproportionately adverse impact on lower income and lower wealth communities. What are the 2 or 3 things that, if Congress invited you today to come in and instruct them on what needs to be done? Well, I guess, first of all, is there a pathway for a federal solution to overlay on top of these 5,000 disparate local sets of rules and practices? And what could that even look like?
Yeah, so I mean, that in itself is an extremely complicated question that I've had students spend their whole paper trying to wrestle with, like what are even the federal levels that could be brought to bear on bail reform. There are some of the obvious ones, in that the federal government can create a spending program that incentivizes states and localities to get their houses in order. And sort of advise on best practices here. There is, as I've said, there's a number of ongoing constitutional litigations that that actually these local bail systems are so systemically abusive. They violate the Equal Protection Clause of the 14th Amendment or the Due Process Clause. You could really pile up the amendments here.
Yeah,
Right to counsel, presumption of innocence, ability to prepare a defense, all of these. But the leading theories in many of the federal constitutional litigations are equal protection and due process. Some listeners may wonder why excessive bail is not really on that list, and that's just kind of an anomaly of the Supreme Court's interpretation of the excessive bail clause, which really untethers excessiveness from money amounts. So it's really hard to get a grip on what the excessive bail clause can give you. But given the disparities we've talked about, equal protection seems to be a viable theory. Certainly there is some historical evidence that are, some of our main vehicles for civil rights litigation, like Section 1983, the main federal statute under which civil rights claims are litigated. And one of the issues it was meant to address was disparate bail practices in the Reconstruction South, as a response to the end of slavery and the Black codes trying to find ways of reinstantiating the kind of master-slave social order. I mean, bail was one mechanism of that attempt, and therefore bail was one target of the original 14th Amendment and the operative legislation. That's a difficult argument to make in federal court. Actually, there's been a whole lot of procedural doctrines, federalism doctrines, layered on since the 1970s that make it really difficult for federal courts to look to state court proceedings and especially enjoin them or tell state judges to do things differently. Judicial immunity is a really big barrier in these litigations. It's understandable that you have to have judicial immunity in any system of judgment, where just by its nature, judgments are going to leave aggrieved parties. And so if aggrieved parties can always sue the judge that rendered a judgment, you'll never get anywhere. But in the United States, our judicial immunity has been sort of so built up that even when judges do manifestly arbitrary or unjust things, it's very difficult even for a federal court to hold them to account, notwithstanding the historical record that this is exactly what 1983 was meant to accomplish. Nevertheless, so we have seen some successful litigations in federal district courts against Harris County, Texas, against San Francisco city and county in California, against smaller municipalities. So one of the things that has produced, I'm thinking in particular of Harris County, where the case against the misdemeanor bail system was settled in a consent decree. So this is partly a story of what the federal level can do through the federal courts, but it's also just partly, here are some best practices now that were negotiated between the parties to this case. I think the first thing to say is that it's really significant that this was a misdemeanor case. The misdemeanor level is where you can have some of the most rampant abuse in the bail system, which might be kind of surprising. You might think felony is where you run into more problems, but in something I see in my historical sources in the 19th century, people could not even be arrested and committed for misdemeanor charges. So there really wasn't a bail system for misdemeanors up until late in the 20th century. The problem with misdemeanor bail is that, if you could challenge the bail amount or say it's unaffordable or seek different conditions, by the time you get a lawyer appointed to your case, by the time that lawyer could file a motion, by the time the court could hear an appeal of your bail, you've probably spent 2 to 3 weeks at least in pretrial detention. So you've lost your house, you've lost your job, you've lost, custody of your children, perhaps, by the time you can even sort of raise the argument. Whereas if you plead guilty to the misdemeanor charge, you can probably be released within 2 or 3 days of arrest. As very often the sentence in misdemeanor cases is time served, by which the courts mean time served pre-trial. It's sort of a sentence first, convict later system. And so that disparity between, going through the process of actually challenging the bail in your proceedings will take you weeks, and you'll have to suffer through detention in all that time, versus just plead to the charge, take the hit on your criminal record. Often defendants don't understand that this then is the thing that's going to go into the algorithm for next time, right? Now you have that misdemeanor conviction.
And follow them in other ways.
Right, and you may lose the job anyway, because now you have a conviction on your record and everything else. But bail becomes such a massive lever for plea bargaining that the most misdemeanor, it's just, this is intuitive, but we now have scientific studies establishing this. It's so predictable that someone who is detained on a misdemeanor charge is going to plead guilty to the charge, or someone released may plead guilty to the charge, but you see much higher rates of exoneration, or charges dropped, or lighter sentences if someone is released pre-trial on misdemeanor charges. So some of the things that Harris County has done through its consent decree, and which, contrary to certain reports by, let's say, the insurance industry, seems to have not affected rates of crime negatively at all, if at all. It is some things are just is very common sense. Like right now in most misdemeanor systems, court dates are set arbitrarily. Your court date is whatever the court tells you it's going to be at whatever time the court tells you. And you have to show up at that time, even if you're going to wait half a day before your case is called and the judge actually speaks to you. And half the time the judge isn't speaking to you at all. It's just your lawyer is speaking for you, and you have to be there because the court says you have to be there. There's a large way in which the misdemeanor system is really just compliance theater. You ask people to show up to a bunch of arbitrary things and wait around for an arbitrary amount of time. And if they do that, then you're not so worried that they're socially deviant. You can move on to the next case and sort of release them from any further obligations. So in the spirit of, reform to the system anywhere is kind of reform to the bail system. Some of the things that Harris County has done, which I think been the most ameliorative of the bail system, is just sort of create open court hours. So, the judges are there all day, every day. It's not like if you're not there at your specific time, you'll miss the judge, they're circuit riders from the 19th century. So, defendants are given a span of time. Within the next 3 weeks, you need to come to court. And when you come to court, we'll pull your file and we'll see what you need to take care of then. Which, many times when people miss, especially misdemeanor hearings, they're not fugitives from justice, right? We know where they are. They're at their homes, they're at their jobs. It's just, they couldn't take off at that particular time. Childcare fell through. These are people who live at the margins as it is. So, creating open court office hours, basically. The other thing Harris County has done is made really clear to defendants which hearings require them to appear, because, it's a constitutional requirement that the defendant has to be there personally for a sentence or something like that, versus hearings which, if the defendant wants to waive their appearance or just have the lawyer speak for them, they're free to do that. They don't need to come into court. These are all reforms that are very much short of abolition, right? So if your takeaway on the systemic injustices of our system are we really need to defund and abolish. This is not it. And probably there is a whole lot of misdemeanor charges that just need to be taken off the books in Harris County. But short of that, if you're going to maintain the criminal justice system you have, just some of these very slight procedural changes, letting defendants treat their court dates like they would treat sort of a doctor's appointment, reschedule if they have an emergency, do all of these things without issuing a bench warrant, without sending the sheriffs out, or the bondsmen calling up their bounty hunters and things like that. Are creating massive improvements to the system overall. I think the other thing that has been really helpful in Harris County's case in particular is that the press has been very responsible about the litigation there. And the Houston Chronicle is a kind of right of center press. It's it's not it's not an abolitionist rag by any means. But they followed the constitutional trial there very closely. They reported on the arguments. They kind of spotted the illogics of the system and defenses of the system, that if someone can pay the money amount and get out, but why is that less of a threat to public safety than someone who gets out without paying the money amount? What is it about money that makes you think makes people safe? It's kind of a drumbeat of the press, and the Chronicle there, as I said, has been very responsible. As cases have come up where people out on pretrial release have done bad things, the press reports it, but not in a kind of Willie Horton kind of way, right? And the press is keeping on top of the monitor and compliance reports, and is really keeping a skeptical eye on the prosecutor and the judges that are running the system. Are they really fulfilling what they were supposed to do according to the terms of the consent decree? It's kind of a night and day contrast from what we saw in New York. After the legislature passed a pretty modest bail reform, which was, basically most misdemeanor charges would not be eligible for cash bail, right? So judges had to find a way to release misdemeanor defendants. You could come up with conditions, you could order house arrest and, a variety of things, but could not use cash to detain people in New York. The local press went wild, accusing legislators of endangering the public, of blaming every kind of increase in crime on the system. And they were doing this before the reform went into effect, because it was passed by the legislature in the summer. It wouldn't go into effect January 1st. In November, the press was decrying, the ill effects of the bail reform that hadn't even happened yet. And we're seeing, much of the same thing with people blaming the defund movement for the crime spike, even though not a single police budget has been cut in the last 12 months in response to the defund movement.
Oh my God. Well, I have to say, I can't remember doing an episode where I have felt like I said less than in this one. I mean that as a compliment, because I'm sitting, I've thrown a few questions out, but I've learned so much. And I think this is what we were talking about earlier, that it's part of addressing the problem is greater awareness of the problem, and how these different points in the criminal justice process impact one another, and how in many ways many of these roads do lead to the issue of bail. So I've learned so much and appreciate having had you on so much. So Professor Kellen Funk from my alma mater, Columbia Law School, and helping us round out the subject of bail reform, and really the much broader and hugely important issue of criminal justice reform, and why it is so important to communities all across this country that people learn more about this, understand it better, and are involved in the process of addressing these issues. And so to that, and for that, thank you so much. It's been a great pleasure to have you on.
Thank you. It's been my pleasure as well. Thanks so much for the invitation to be on the show.